It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are back here in the studio, WTAN, for FLA Law on the radio. My name is Jacqueline Bryan. As you know, we are the personal injury lawyers at Perenich, Caulfield, Avril, and Noyes. Today, I have my special guest and co-host with me, my colleague, Lori Robinson. Please say hello to our listeners.
Great to be back, Jacqueline.
Thank you. I appreciate you joining me once again on this Tuesday. As our listeners know, we are here on the air every Tuesday at 5 o'clock on your drive home to answer your legal questions. That's right. This is a live legal call-in talk show where you can call in with your legal questions. As I mentioned, we are the personal injury lawyers at Perenich, Caulfield, Avril, Noyes. You can find us at voiceoftheinjured.com. Most of what we talk about tonight will be in the personal injury realm. But of course, you can call in with your legal questions and we'll take a stab at whatever you might be dealing with and try to point you in the right direction. But of course, before we jump into tonight's show, which I think will be fun and interesting as always, I want to give you our contact information on how to reach us tonight and how you can call in and get your questions answered over the air. First and foremost, we'd love to hear from you on the radio. So the number to call into the studio is 441-3000. Again, that's 441-3000. That's how you reach us here in the studio.
And if you're calling from outside the area, it's 727-441-3000.
You got it. Thanks, Matt. Make sure you get that 727 area code in order to get through. And that will put you straight through to us. And Matt will get you into the studio and we will answer your questions live over the air. Now, if you're one of those people who don't like to hear themselves on the radio and you want to get your question in but don't want to call in, we are streaming live right now. You can see us in the studio on Facebook Live and YouTube. So first, let me tell you how to find us on Facebook if you are a Facebook user. Just type in our name, Perenich, Caulfield, Avril, and Noyes Injury Lawyers. Put it in your search bar. You should be able to find our live feed right now. You can see Lori and I sitting here in the studio. Type your comments in the chat box, and we'll be able to read your question and comment right over the air. As far as YouTube, if you're not on Facebook, YouTube, you can find us the same way. Perenich, Caulfield, Avril, and Noyes Injury Lawyers, and you can see our live YouTube feed there. Perenich is spelled Perenich. So your repeat listeners, people that are new to the show, feel free to call in. That makes the show exciting. If we can get some calls tonight, the lines are open. With that being said, for some of you who don't know, I'm just going to allow Lori just to give a brief bio, tell you about herself, because we're going to be asking her some really interesting questions about trial and civil litigation tonight. So go right ahead, Lori.
Well, I love being here at the WTAN studios. I don't know why, but I'm once again reminded that my father started at WTAN in the late 50s, many moons ago. And so
Great fun fact.
Yeah,
there.
It's really a very, very fun factor. So I basically grew up in Clearwater, but after law school at the University of Florida, was in West Palm Beach for a number of years. And then I've been with our firm for 25 years now.
Awesome.
So, of course, obviously, I was like 10 when I got started with the law. I was like a prodigy.
I was going to go younger than that. So,
really. But one of the things, I've just been so blessed. I love the practice of law and I love our firm. We're in a position to help people through a very inhospitable system, basically, if you are injured in an accident. So fortunately, because of the opportunities I've had for experience, I've been able to become board certified as a civil trial lawyer, which is a distinction that, I'm proud of. That's something that a small percentage of attorneys are able to achieve. And so it's something that it kind of bespeaks what I've spent my life at, really, frankly, is trying to help people in the context of a legal issue, which is personal injury in this situation. And, we always hope that they don't have to go to court, but it's very important to have lawyers, and our firm is including yourself, we're all very dedicated to taking cases to court if that's what needs to happen.
Absolutely.
And as a result, it's possible to resolve many cases without that, but that's a part of the firepower that we have, and that's something that we certainly enjoy very much offering to clients of the firm. So.
Absolutely. That's definitely a benefit when you know that the attorney you hire right after your car accident or your personal injury matter will be the same attorney that can take your case all the way in front of a jury. That's reassuring, I think,
I think so. And I think the other
clients.
thing, I've had a couple of people I've talked with lately that have come in from other law firms that will remain unnamed. but the thing that I love about what we do is that it's personal. We have a personal relationship with our clients. We have wonderful staff, paralegals, legal assistants that assist us. Nobody is going to be in a situation where they're not talking to their attorney. And I think that's very important for the lawyer to do the best job.
We can pride ourselves on
basically,
that for sure.
And not to mention that it certainly makes it easier on the individual, so they're not left wondering what the heck is going on.
Oh, absolutely. Before we dive into the trial topic that we want to get into, I think that's important that you mention. At our firm, I think the personal connection that we make with our clients starts at the very beginning. We meet our clients at the intake appointment. And I think that has actually helped me throughout my practice, because sometimes you get those facts in the very beginning that sometimes can get lost as you begin to litigate. And if you're able to recall that conversation you had with the client in the very beginning, when they said X, Y, and Z about their case, sometimes that information can help you build a stronger case because you remembered what that client told you right after the accident. And so I think that helps tremendously to have that personal contact, face-to-face meetings with your client when they can tell you all the things that they're going through and all the things that they're dealing with.
And remember how individual it is. So each person in a personal injury claim, the damages are your medical expenses. So in a sense, that's more objective, but it's also the impact on your life. So just kind of getting a feel for that individual from the very beginning,
Absolutely.
I think it makes a huge difference.
Big difference. So I wanted to talk a little bit about trial tonight, Lori. Trial and Lori, they kind of blended together there. But the reason why is because I think there's a lot of things that juries don't get to hear. And I am of the belief that sometimes when there's, high verdict cases or high profile cases that are kind of publicized, sometimes the public can be confused about why the outcome was that way or how come the jury did that. And they don't necessarily always realize that the jury doesn't know or see everything that you might expect them to see or to hear about. And some evidence, will never, get into the jury's purview. They may never know about it, may never see it. And there's sometimes reasons, for it behind the law, whether I agree or disagree with those reasons. But I think it's good to talk about it tonight so that people get an understanding of what the jury will see, what they won't see, and things you can't even talk about in certain civil litigation matters. So if that's okay with you, I think we should jump right on into it. And one of the things is that evil word, insurance. Insurance. And I'd like to know from your perspective and what the law says about insurance. Can you talk about it at trial? And is it something that we can really introduce during a trial?
So it sort of depends, but the basic answer is no. So part of what's going on there is that the jury is going to make a decision about the damages in the case, the responsibility in the case. And the rationale is that if they were to know that there was insurance coverage, that they might be more willing to make large awards than if they didn't really know what the situation is. So there's a good point to that, but there's a bad point to it because, as you can imagine, because you have a situation where if you bring a legal action, you're suing an individual. If you're suing a company, people are going to assume more likely that there's an ability to respond. Right. But if it's an individual, the jury can't be told that there's an insurance policy that would cover the damages or a significant portion of them. And so that can be very difficult for people. Now, we can have other situations where, if it's a situation where there isn't insurance and perhaps you are suing your own insurance company under the uninsured motorist policy that you purchased, the jury is going to know there's insurance, but you still can't really talk about it too much. I mean,
Exactly.
you can't go on and on and on about, what their responsibilities are to their policyholder.
Right.
Yeah, because of that same rationale, that perhaps that would make the jury be more likely to make an award that's not connected with the damages. So and most people don't realize that. They don't understand that. I mean, if you are in a trial and something about insurance slips out before the jury, then the judge is going to declare a mistrial.
Right.
Unless in almost every instance, that's what's going to happen. It would be up to the judge to decide in the particular case. So,
and that's it. We go home and have to start all over.
Right. Right. And you never want to do that. I mean, nobody, it's hard for everybody going through a trial. And if you've gone through the whole thing and then now you have to do it again, which does happen, but you don't want to.
Exactly. So if, little Miss Jane Doe, an elderly woman, she comes in and she's sitting at the defense table and the jury, sees that she's a defendant. Is it basically a situation where they never know if she has $10,000 of coverage or $1 million of coverage behind her? Is that basically what that says?
Yeah, they're not going to know anything whatsoever about the insurance aspect of the case and how she would be able to pay any judgment. So as a practical matter, it is an issue, because obviously jurors could be sympathetic in that setting, just like the defense always worries that the jury would be sympathetic to our client who's been injured. Yeah. So it is a factor, but we've operated under that set of rules for a long time, and it's still. I would say by and large, juries try very hard to follow the law and do a good job.
They do. And the ones that can't are supposed to share that during the jury selection process. And I remember one of the last trials I did with Brian Caulfield in our office, that was a big issue that came up during the voir dire. Is there was one particular gentleman who said, I need to know that information. I need to know if there's insurance here, because if there isn't, then I'm going to have a hard time making award for damages monetarily against, this individual if there's no insurance. But if there is, then I'm fine sitting on this jury. I can understand that. I understand how insurance works. But if there's not, I need to know that in order for me to proceed.
Well.
And of course, he was, of course, excluded for that reason. But it got everybody else thinking, that's true. I want to know about the insurance too. And so it ended up almost tainting the jury pool in a sense when that insurance word gets thrown out there.
Right. It's a difficult thing to handle. We always, as lawyers, try to help the jury understand that, other factors are not for you to be concerned about. You need to just address, what the facts are in this case and the law as it's applied. But, it's definitely something that we think about and as lawyers try to craft our case, never violating the rules, of course, but try to craft our case and our presentation in a way that helps the jury to come to what we believe is the right decision.
And so with that being said, is it also to be assumed that since we can't talk about insurance, then as far as who is representing this individual sitting at the defendant's table, this lawyer, is that lawyer representing the individual, or is that lawyer representing the insurance carrier?
Right. And so once again, the jury is told nothing about this.
Right.
And, and a lot of people that go through an experience, even have an auto accident, until they have that happen, they don't know anything about this. But if, one of the purposes of having insurance is that if you get into an accident and unfortunately you've caused it, you get sued or somebody believes you've caused it, you call your insurance company and they hire you, their lawyer, basically. Now, their lawyer's fiduciary duty is to you as the insured.
Exactly.
They are representing that insured, but they do work for the insurance company.
Right.
So
it seems like an innate conflict of interest there, but hey, I don't make the rules. But
no, and actually, honestly, what would people do? They've got so ethically, the lawyer is bound to represent the interests of that insured. Where they cannot, that needs to be disclosed.
Exactly.
But it is a part of the system that ultimately allows for there to be insurance coverage so that people have a way to recover damages.
Right. Yeah. And I remember sitting in on a trial, I think as a law student, and there was a situation where I think the adjuster had come to trial and was sitting near counsel table, and she opened her laptop and the background had the insurance logo on it. And there was some concern that the jury had seen that. And unfortunately, I didn't get to really see how that ended up playing out because I was just kind of popping into the courtroom. But there was a big hubbub about if the jury realizes who's sitting there at that table and who the carrier was. And it turned into a little bit of a thing. But
especially tricky since that was their fault.
Exactly. That's something that they would obviously want to take those steps to not have that there. Or I think, I think it was like a jingle almost. It's like when the computer booted up, it played like their jingle or something.
That's funny.
That was interesting. And it just goes to show that the jury, it's very, very particular about what the jury can see and hear and how it's going to influence the trial. The plaintiff in that case, I'm sure, would have loved the fact that happened.
Right.
It's like, okay, well, now we know it's out there. We didn't put it out there, but of course, there probably was some sort of action that was taken to try to cure it. I don't know. But with that being said, I think that does kind of play into the whole David and Goliath type conversation at trial when they know that this is a major insurance company here backing that individual. It does, I think, kind of skew the perception as far as maybe they're going to be more likely to award a higher verdict if they know that insurance is involved versus not.
And I think, probably most people, certainly somebody on that jury probably is likely to have a sense of that.
Sure.
But they don't know the precise nature of that. So we know if we have a situation where we have a corporate defendant, a larger company or something of that nature, then it's less of a concern for us that a jury is going to be afraid to make a damage award that is actually commensurate with the real damages,
right?
Which is what we're really talking about here.
That's exactly what it comes down to.
Yeah, right.
Yeah. So then let's talk about health insurance then, because this is something I'm not as, versed on. So when it comes to what the jury can know about health insurance, which is different from auto insurance, because the health insurance provider is not the one that's going to pay a verdict. They're the ones that may have been paying some of the medical bills throughout the course of the case. And so there's issues there, I guess, in terms of what the jury may or may not know about how the health insurance payments are handled after the verdict. But what can you say about health insurance during a trial?
That this is going to be a very interesting moving target for us now.
Especially now.
Right,
yes.
Because it used to be before March of this year and the major changes that were made to the law, that it was very clear that nothing that would be considered what they call a collateral source, anything outside of the parties that are in the at-fault party and the injured party, nothing would be brought before the jury. They might know about the PIP because the law set forth there's that PIP, which is your auto insurance that just pays up to $10,000 regardless of fault, and that's set off against the $10,000 is set off against what the expenses are, and so you can only really recover above that. So that can be handled in different ways, and the jury might know about that. And there is an instruction that tells them how to deal with that. But nothing about health insurance. None of that should come in, and it shouldn't really, because it's very confusing. Yeah, basically, the jury can award the damages. Oh yeah. And so if your health insurance has paid damages, then high likelihood that they will be entitled to what's called subrogation or reimbursement, and that is handled outside of the jury after there's a verdict. Those are things that are handled after the trial is over with and not before the jury. But there are complicated rules that go to different situations there. But now what we're going to be dealing with is, and it's going to be interesting to see how it plays out really, because now with the new law, it appears that the defense is going to be able to require admission of available coverages such as health insurance and that kind of thing. And it's going to be very confusing, really. And so that will take some sorting out. Now, again, many people are going to assume that there probably is some health insurance and all of that. But you can see here, we shouldn't be making assumptions. And the jury, it's so much simpler and less likely to have an error if they're just asked to decide, who's at fault
Absolutely.
and what are the damages, and then the other parts can be sorted out.
Sort out after the
but
fact.
as you and I know, the legislature did not ask us.
They didn't.
In fact, they very speedily signed on the dotted line. The governor signed on the dotted line to get this new law in, which is designed to try to, from the perspective of the people that pushed it, they think it will be helpful in reducing insurance rates or something. I don't know, but it's going to be a real can of worms to sort out in the courtroom.
Oh, yes, it is. And even as confusing as it probably already was for the average juror, I think it's going to muddy the waters a bit, but we'll see how that starts to play out.
Right.
So before we go on the break, I wanted to ask you a little bit more about what the jury does not get to hear about. But as we are talking about these topics at any time, feel free to give us a call, interrupt us. We want to hear from you. The number is 727-441-3000. Tonight, we're talking about jury trials and the things that juries do not get to hear about during the trial. So we've touched on insurance, that naughty word that you cannot say during a civil trial. But what about police reports?
Oh, yes. So this is something, as you know, every client comes in and they feel like, well, the police ticketed the other person. Mm-hmm. That should be the end of the story. But you're actually not allowed to introduce into evidence anything about what the police officer determined. Because, of course, the police officer, unless they were an actual witness, they do not really know.
Which is rare.
Right. It would be very rare.
Mm-hmm.
So while it may be helpful in the negotiation of your case with the insurance company, because outside of the actual trial, people certainly look at that, but it's not actually admissible. And so in a civil case, the police officer may not even be called as a witness because it's unlikely, unless there's something about where the cars were physically, but usually they're even moved often, by the time the police officer gets there.
Arrives,
So that cannot come before the jury. The fact that the other driver got a citation cannot come before the jury. And there are times when the negligence issue is fought. So say it's like a left turn at a traffic light and there's an issue about failure to yield. There are a lot of situations that have some elements where you can kind of argue a little bit of responsibility both ways.
Exactly.
Those are things that you're not going to solve that by who got the ticket.
Right. And I think a lot of clients come to us and they're kind of gripping onto that accident report. Well, this says this and this is how it should be. And they're almost, hanging their hat on the police report, not realizing that who got cited or the things that are listed in the narrative of the report are not coming in.
Right. They're even, a witness statement has a special privilege, the accident privilege, so that the witness speaking to the police officer, what they said, you're going to have to get that another way, not from that police report, except in very unusual circumstances, because the law wants to encourage people to actually report and cooperate with the police.
And you anticipated my question. It's like, well, why is that the case? Well, I think that the thinking is that they want people to be honest with the police during their investigations. Yes. And if they know that could later be used against them as an admission of liability or fault, then they may not be as honest with the police officer, right?
And that seems reasonable. The other part of this, though, is people listening, should realize that if it's a situation you were in an accident and you did get cited or the other driver did not, but you really don't feel it was your fault, it's worthwhile to review those circumstances.
Absolutely.
Because just as we said, the police officer and the ticketing, that really does not determine.
It does not. And it could be some sort of shared fault, some sort of comparative fault there as well. And
yes, so we have that concept in the law and the jury will be asked, where there could be some degree of responsibility on either the defendant or the plaintiff or both. They get to estimate that percentage. And then thank you to our new law, because how precise can any of this be?
Yeah.
If they estimate that percentage at over 50% on the other party's part, then you will not be able to make any recovery, even though, let's say it's 51%, obviously a very strong amount of responsibility on the other part. And normally what would have happened is the damages would just be apportioned based on those percentages,
exactly.
Which seems like a fair way to handle that, actually.
Yeah. Well, then that actually already touched on my next question, which was going to be the citation itself. So the fact that someone got ticketed and they were the person that received the citation, maybe they paid the citation, does that party's accepting of the citation and paying it, does that mean they've now admitted guilt and we can use that against them at trial?
No, and they'll see on the citations that you can resolve that in a way that is not admitting guilt for purposes of the
like a
automobile
no
accident.
contest almost.
Right.
So that doesn't necessarily work in our favor. If you are hit by someone who pays the ticket, that isn't just an automatic admission of guilt or fault, unfortunately. So that brings us to a good stopping point to try to take a quick break. The lines are open. We are still on Facebook Live. I see we have some viewers watching. We're going to take a short break for a commercial. When we come back, we're going to continue the conversation about things juries do not get to hear about during trial. Here with our board-certified trial lawyer, Lori Robinson, answering your questions on the radio and also on Facebook and YouTube Live. We'll take a quick break and we'll be right back with more conversation about trials and juries with Lori.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
And we are back from break. This is FLA Law on the radio, your live legal call-in talk show. Tonight, we are here in the studio with my co-host and colleague, Lori Robinson. We're talking about jury trials and what juries get to hear about during the trial. We've touched on a few interesting topics, but of course, we are here to answer your questions about this and any other legal topic that you might have questions about. As you know, we are personal injury lawyers at Perenich, Caulfield, Avril, and Noyes. You can find us at voiceoftheinjured.com. And we are here to answer your questions live on the air. That number, once again, is 727-441-3000. And we are still live on Facebook and YouTube at Perenich, Caulfield, Avril, Noyes Injury Lawyers. So feel free to jump in, leave a comment or a chat, and we'll read it out over the air as well. But of course, if you're on the drive home, drive safely and listen to kind of what we've been chatting here about. So I wanted to talk again about the things juries do not get to hear about during a trial. And one of those things is settlement discussions. So obviously, leading up to trial, there are times where many opportunities, I would say, where the parties can sit down and try to resolve things either formally at a mediation or informally between counsel or what have you. So tell me, Lori, how does that play into a trial, and what information, if anything, would a jury get to know about?
So the jury is not going to be told anything about settlements, and that's something sometimes people actually many times have had to explain to clients that in settlement negotiations, that is something that's really separate from what you would do at trial. Mm-hmm. If you are actually all the way at a jury trial, what you're going to be asking the jury to consider in damages is going to be the full measure of those damages. Mm-hmm. Settlement, by its very nature, is going to be a compromise.
Right.
So it's not going to be that number. So all bets are off when we go before the jury, and they're never going to know anything at all about discussions that the parties have had regarding settlement. which is a good thing. That should occur in a way that is private and confidential. I know, obviously, as a part of the litigation process, we would go through what's called a mediation.
Exactly.
Which is a settlement conference, and everything there is confidential. Even our client is not at liberty to go share that information.
Exactly.
You really have to keep that, private and privileged. So the jury is never going to know. So that's something people don't have to worry about. That once you're at the point of actually trying a case, now you're before that jury of 6 people, asking them through your lawyer for the full measure of your damages.
Exactly. There's no longer a compromise at that point. So you made a good point that I want to kind of break out into 2 questions. So on the good side, I think it is good that mediation and the settlement discussions are confidential and don't come into trial, because sometimes you're at a point of compromise, like you said, where you're willing to take maybe less than what the case is really worth in order to avoid the full measure of all the things that go into a trial and continuing to litigate. And so if that information were to come out to a jury, it could obviously hurt your position. Now, on the other hand, I think it's interesting or worth discussing when it's a situation, for example, where the defense has presented an offer that's extremely low, where it didn't allow for any type of discussion or the ability to try to resolve it based on how low the offer was. And it almost is something you wish you could tell a jury.
We're here because they are so unreasonable.
Exactly. We wouldn't have been here had it not been for, the $500 offer that was made or something like that. So I could see how that could, be helpful in some points. But as you said, I think it's best that kind of conversation not come into a jury.
Because what's supposed to be happening in a court of law is impartial jurors are listening to evidence and arguments from both sides and making a decision. And so, one of the things we will talk in terms of what the case is worth or what we think the value of the case is. But in reality, the value of the case is ultimately what a jury says it is. That's the value, because
that's how much your case is worth.
There's no set standard for determining those things. I mean, you have certain medical expenses, maybe you've lost wages, and those things can be a little bit more objective. But future medical expenses, no one's ever really going to know exactly what that would be. So you present evidence, and a jury would make a determination based on that. And then, of course, the component of pain and suffering and emotional distress and just the impact in your life. The jury instruction even says there is no exact standard for determining that. The jury is to use their own experience, in assessing that. So just now with the settlement values during the course of the case, insurance companies have opinions of what they think the range is, and probably we would
software.
too. Right. But even that, the ultimate value is what some jury actually says it is.
Exactly.
And then short of that, it makes sense to discuss settlement, mostly because of the great expense of going to trial and the uncertainty, because obviously we don't know who will even be on our jury until we're standing in front of them.
Exactly. Now, I think it also kind of plays into this conversation I had with an attorney before who was kind of frustrated in the sense that leading up to trial and during mediation, the opposing party never admitted liability. That was something they disputed all along. And then on the eve of trial, as they get before the jury and prepare their opening statements, they switch.
Oh, they're so reasonable.
Yes, we've admitted liability in this case. And so it does, unfortunately, have that a little bit of a double-edged sword. It's like you can't really tell them that.
As advocates, we don't like that. And we try to find a way, just as they would on their side, to somehow get the idea out. But truthfully, we can't really. I mean, the facts, the jury just has to hear those facts, whatever the ones are a dispute before them.
Yes. Yeah. So that is always something that I've thought was quite interesting, how that dynamic shifts, right before trial. It's like, oh, we've been reasonable and willing to accept, our responsibility for this accident. It's like,
not so much.
Not quite, right? So, okay. So another topic that many lawyers learn about in law school, I'm going to give you the legalese first, and then, of course, we can break it down for our listeners. But there's this legal notion called subsequent remedial measures. That is something that a jury does not get to learn about, and I'm sure listeners have no idea what that is. So, of course, Lori, can you explain that?
And a nice legal sounding phrase, right?
Yes.
Subsequent remedial measures.
Yes.
What the heck is that? And I'll just give a simple example. Yeah. So say you're walking down the sidewalk and there's an obstruction in the sidewalk. There's like this cement thing that's sticking up and you trip over that and you hurt yourself. And you come to your lawyer and you explain what happened. You took pictures of all of this. And then because it happened fairly near where you live or work, you notice that they've fixed the whole thing up, and you take pictures of that. And you say, see, that proves that they knew that there was a problem there. Well, the jury never gets to hear that because the policy of the law is we want to encourage people to actually make repairs where they find that there's a problem. So unless the case develops in a way where the defendant tries to there are ways they can open the door to getting that in by denying that they could have done anything or something like that.
Saying that it wasn't feasible to fix it or something like that.
But in the normal situation, we wouldn't be able to mention that. And that's something that's always difficult for people to wrap their mind around because it seems like such an obvious evidence that it shouldn't have been like that. Now, I will say,
thing speaks for itself, right?
Right, res ipsa loquitur.
Exactly. We're throwing them all out there today.
But I would say that, honestly, the thing that has surprised me more than anything in my many long years of doing personal injury work is how frequently there's no subsequent repair.
That's actually true. You're right.
And I would still say that I tell this to clients all the time, that it's important to bring the claim, if you've sustained injury, to recover your damages. But it's also important to basically bring some accountability to the people that should make these things safe for people. Right. And so it's like, it's surprising to me how often that doesn't occur, but it wouldn't occur at all. If you didn't, very rarely, if you didn't at least try to hold people to account. So, but we aren't going to be able to tell the jury about it.
Exactly.
If they do the right thing, we can't tell the jury.
Exactly. And that's the unfortunate part that I think a lot of clients have a hard time grappling
that's always a difficult one to
They definitely want to run to us. Look, it's been fixed. Can't we use that? Unfortunately, we cannot. So,
but we're lawyers. We're going to find other investigative ways to bring out that it was negligent.
Right. And one thing I like to point out to my clients is that we don't necessarily want to look, after the fact. We kind of want to know what they knew prior to that.
Right.
So the things that they would have seen, known, reports, complaints, other incidences, those are the things that are really important and key. What happened leading up to your injury? So that's something to kind of think about if you have an injury case, not necessarily what happened after, but what was going on before. So that's good. So subsequent remedial measures, the thing that the condition or the dangerous issue, if it gets repaired, unfortunately, a jury will not get to hear about it unless the door is open, like you said, and there's some other way to get that in. But and necessarily cannot prove the guilt or fault or liability of that party. So with that being said, we touched on this topic a little bit before, but I want to make sure I don't glaze over what happens when there are these collateral sources that you mentioned. You talked about it earlier in the show, that health insurance is like a collateral source. And so typically when you're in a trial, you're not talking about those different, payments that were made, to bills and things like that throughout the case. And why is that? What happens after the fact? Because it doesn't just go away, right? They're still going to be dealt with somehow.
Yeah. So if it in a case as they have been tried, prior to the change in the law, so it's a little bit simpler. So if you get a jury verdict and say you had $10,000 in bills that were paid by your health insurance, if that was the case, then in that scenario, the jury would know what the bills were, and they've made an award for your medical expenses. Post-trial, after the trial, either by agreement or if there had to be a hearing before the judge, if there wasn't an agreement, the insurance company, it would depend on the situation. Almost all insurance companies will have some kind of a reimbursement provision, which will usually allow a discount for the attorney's fee percentage and costs.
Right.
But many insurance companies, if you're working for a bigger company and you have what they call an ERISA plan, will want 100% of what they pay. 100%.
Yeah. Very difficult.
And sometimes they will negotiate some. Obviously, we do that. There are a lot of different factors, but so and the law says, the collateral source, the jury shouldn't be distracted in determining what the damages are by hearing about all of these different payments.
Get into the weeds,
that.
right?
Right. But the law that says this should be handled after the trial is obviously there should not be a double recovery is the idea behind that if you've actually been, if you've had it paid by health insurance, then this is a reimbursement that should go to the health insurance.
Right.
So that's can all be handled, has always been handled post-trial. People that are on Medicare, Medicare, Medicaid as well, but Medicare, they're going to get back what they paid, less they do deduct a percentage for the attorney's fees and costs. But so, pretty much it's going to be 65%. They're going to get back what they paid. Now, what ends up happening, though, is that the normal charges, health insurance charges, people will say, did you see that was like $100,000? Well, the bill might be $100,000, but depending on Medicare may pay 20% of that. If it's health insurance, maybe it's 30% of that. It's like and it just depends on the health insurance company you have and whether the provider is in their network. And that part is very confusing.
Right.
But it's not confusing what they paid, so it can be handled after the trial.
Exactly.
Yeah, and that's normally how it would be.
And so when you have these post-verdict set-offs that the jury doesn't know, the judge is obviously going to make these different set-offs. Do you feel like the jury has a real understanding of what they actually awarded then if their verdict is going to be reduced? In
some instances, they may not really, So what, and there is an instruction that tells the jury not to consider these things, just make, the awards based on the evidence that they have. And in some, it does make it a little more difficult for a jury to actually have an appreciation for what they're doing. And depending, it's almost a bit of a trial strategy. Sometimes we will, by agreement, just agree that we're only going to be asking for medical expenses that are outstanding or so, there are different factors that come into play with experienced lawyers trying to make the best presentation and the easiest presentation for the jury so the jury does appreciate what they're doing. But in the most basic sense, the jury, ultimately they got that verdict form and they're going to be adding up the past medical expenses, the future medical expenses, wages if that's an issue, past and future, and pain and suffering if there's been a permanent injury in an auto accident setting. It could be present in any other type of case without that. But and it is a factor. So juries do think about, what the number sounds like, and yet they're not really told. They don't know anything at all about the standard attorney fee agreements.
Yeah, and that's what I was just about. That was my next question is what does the jury know about the fees, the costs?
Right.
Do they get to hear any of that?
No, they don't know a thing in the world about that. Yeah. And honestly, I don't know how would we ever make it. There's already plenty for the jury to consider.
Yes.
So letting them just decide the facts of liability and then the facts of the amount of damages.
Right.
That's a lot right there.
It is. That's challenging for even lawyers.
Right.
So you're asking lay people to try to come up with all that.
The idea of a jury system is you've got 6 people and they're all going to have to agree because the jury has to be unanimous in Florida. And so they're all going to have to agree.
Exactly.
And, we all know, get people around a table talking about something. especially a legal case. It's hard to get them to agree.
Hard to get everybody to agree, right? So, and that kind of plays into what you mentioned about the fees or the cost. So, unless there's like a proposal for settlement, juries may not realize that the fees and the costs are not just automatically getting added into a judgment.
Unless the juror has been in a personal injury setting, the case themselves, or had a friend or family member, I doubt very much that there's any real understanding of how that works. And,
exactly.
And they would be, they're told by virtue of what the jury instructions are, what they are to consider. So they cannot consider that.
Exactly. So that is kind of the overall sum of kind of the questions and then thoughts as far as what juries get to hear about during a jury trial. And so those would have been our thoughts. Is there anything other than that you'd like to comment in terms of things you wish a jury would get to hear about or should know as far as the general public when the trials are going forward, that if I could just tell the jury this thing, I think trials would be a lot more fair?
Well, I guess I'm an old lawyer now, and I would say, and I love it very much, 44 years in the trenches and 10 years as a public defender doing criminal, the rest of it all in personal injury. And,
absolutely.
And there, honestly, there are a lot of things that you'd like to be able to, I would like for the jury to understand more about how the fees and the costs and that kind of work. Probably the biggest factor is what it costs to actually try the case. If you have to try a case, it's a very costly proposition, but having said that, I don't know how you would ever be able to share information like that, and it's not strictly speaking relevant to what the jury has to decide. So I wish that the legislation had not made things even more complicated, because I think that just keep them zeroed in. But we'll sort through all that. We'll see what that ends up meaning. But I would say this: the main thing I would say about the jury system is to people listening. No one really wants to serve in a jury usually because it's inconvenient. Depending on your job, you might not even be paid much.
Fair assessment, yes.
But it's so important. So important.
It is our civic duty. And I think the way our justice system is set up, it is necessary. It's necessary that we have good juries, fair-minded juries who listen to the facts and look at the evidence and decide fairly. So.
Right. And the only shot you've really got, of not having some king or person, in charge. It's the only shot you got. So it is having a decision by, what is to be a jury of your peers, as they say. So it is. I think I always say it's like it's got a lot of problems. The system does, but it's still the best in the world.
Absolutely, I have to agree with you there. So of course we've only got a few more minutes left, but if you can squeeze a question in the next few minutes, do feel free to give us a call. The lines are open, 727-441-3000. But we always like to try to touch on a current event whenever we can, if we don't get to gabbing and run out of time. So I think we've got a few minutes to touch on what I think is a very important topic. It's so devastating we have seen happen to that community in Maui. I'm not even going to try to butcher the name of the exact region, but as you know, there were the fires there that basically annihilated this one town and this specific area on the island.
Except for one miraculous church. There's a Catholic church, and I think it's like Lahaina. I don't know if that's how you pronounce it.
I think it might be Lahaina.
And and there's like I'm sure it's a Hawaiian phrase, but I was just reading about this, that it stands for Lady of Victory. Really? And that church, it's probably stone or something, but it is standing untouched. Still standing. And I read an article that said even there were like flowers at the altar. They weren't even wilted or singed, Wow. And of course, they're there to try to bring hope and help to the people. But it's a devastating situation that's occurred there.
Yes. Well, I could imagine how that's going to become a kind of a beacon in that area where that church is. But not to get off on a tangent, I think obviously, being from Florida, we can kind of sympathize with seeing devastation in our own area and how hurricanes and different natural disasters can really impact a region. And so we've, in our practice, have helped people in the past with insurance claims when these kind of things happen. And so I, of course, wanted to get your thoughts on the liability perspective on how things are going to play out. I can only imagine there's probably going to be a ton of litigation, claims being denied. But from what I understand, there's some argument, I guess, against the electrical company in that region about having some sort of liability there. Are you able to comment on that?
Yeah, I think one of the things that, the first thing I noticed, frankly, as a Florida resident, though, is all of these big insurance companies are over there, and they're going to be hit with billions of dollars of claims. And we want our insurance market to improve. Okay. Yes, we're hoping to not have a bad hurricane season and then whatever. But so you'd have the homeowners insurance issues for the fire damage claims. But the other thing that is kind of interesting is, and this was apparently the case in California and some of the other Western states that have had these wildfires, and, their infrastructure is old. And so, and I guess here in Hawaii, apparently, from what I was reading, is that, they had these 60-mile-per-hour winds. There was like a hurricane or something a little bit near, and older infrastructure. And so they're still investigating it, but it seems apparently quite likely that the fires were ignited by this old infrastructure that had arguably not been well maintained. And so that will be the source. It has been the source of claims involving some of the other fires in the Western states, and apparently to a rather large, sizable recovery. Yeah,
I think, which honestly, that Western company, I think in California, is going through bankruptcy now as a result of that. So, my understanding, though, is this a private electrical company or public? Is it something that we're going to be seeing as sovereign immunity issue?
I don't precisely know. I think it may be a private utility there, but those are issues that come up because we talked before about the concept of sovereign immunity, which is an old common law idea, so that you can't just sue the government for anything you might want to sue. Like another thing I'd mentioned to you off the air, I read somewhere that it's said that maybe some of the fire hydrants were empty. Well, that would have been a bad thing.
Oh my goodness,
certainly would seem negligent as heck to me. But that probably is not the kind of thing that you'd be able to sue the government for. But I think these power companies, if they are separate private entities, that they certainly seem to have been able to proceed against the one in California and some of the others. So I think if there's a maintenance issue. And it appears that's been kind of an ongoing issue, that they just sort of operated on the assumption of fixing something when it's broken. But, you think about how old these facilities are, and you can think, well, I think maybe some more effort should be spent on that. And obviously that will be the source of a lot of litigation, I'm sure. It'd be interesting to see what happens.
Right. And I saw something, and I don't know how accurate it is, but I even saw something about the homeowners insurance side of the claims where apparently, and again, I don't know how true this is, but there's already been denials based on technicalities in terms of the zoning.
This is what insurance companies do.
And it's like, oh my gosh, they're already denying claims based on that issue. And it just seems so unfair to. And,
we don't have to paint a broad stroke over every single company. We don't really know. But unfortunately, it's not uncommon.
It's not.
You can see it as a business matter. They got all these huge claims coming their way, but that's what the insurance is for, and they need to step up to the plate.
They absolutely should
and be there for the people, and
they've paid the premiums and entrusted their.
And my goodness, if all the times you need the help,
this
now
is when you need it.
Oh
Absolutely.
my goodness, yes.
Yes. Well, Lori, you have been a pleasure as always. I love having you as my co-host. So hopefully our listeners have gotten some really good information tonight. Even myself, I've learned a thing or two from Lori. So as you know, we are here every Tuesday at 5 o'clock with FLA Law on the radio. I hope you enjoyed the topic about trials and what juries do not get to hear about when the trial is pending. If you have other issues or insurance questions or personal injury related matters, you can find us at voiceoftheinjured.com, usalaw.com. Of course, we are also on all the socials, Facebook, Twitter. I don't think it's called Twitter anymore. Instagram.
It's like X for maybe SpaceX. I don't know what that means.
Who knows? But we're there, and you can locate us that way. We're happy to answer all your questions. You guys have a good night, and we'll see you next Tuesday.
Yes, stay safe. Bye.
WTAN, Clearwater,
FM 106.1,
WDCF, Dade City.
FM 102.3.
Listen.
This is CBS News on the Hour, presented by Indeed.com.
I'm Monica Ricks in New York. Texas is dealing with more extreme weather from Tropical Storm Harold, which has knocked out power to thousands around Corpus Christi, but also from intense heat that's once again hitting the South, Southwest, and Midwest. Odyssey, New York meteorologist Craig Allen is tracking it.
A heat index anywhere from 105 to as much as 115 degrees will be felt in places like Dallas and Tyler, Texas, on up through Texarkana, Jackson, Mississippi, New Orleans to Biloxi, Alexandria, Monroe, Louisiana, on up through Tupelo, Mississippi, Memphis, Tennessee, Hot Springs, Arkansas, all these places experiencing